The Supreme Court has just detonated a jurisprudential nuclear weapon that fundamentally alters the landscape for every single firearm owner in the United States. This was not a minor adjustment of the regulatory dial. This was a 6-3 earthquake that has shattered the existing framework regarding permits, mandatory training curriculums, background check procedures, and the very concept of constitutional carry across all 50 states. You need to hit that subscribe button immediately because the information we are about to analyze is the dividing line between lawful carry and a felony indictment. We are going to dismantle these 10 new governing dynamics piece by piece so you understand the legal battlefield you are now standing on. Rule number 1. Constitutional carry is now the absolute legal baseline. This 6-3 decision has handed gun owners the most potent legal ammunition we have witnessed in decades. The High Court examined the practice of states dragging citizens through months of bureaucratic limbo and demanding justification for a constitutional right, and they issued a definitive rejection. This ruling takes the precedent established in 2022 and amplifies it exponentially, pouring concrete over a legal foundation that every subsequent Second Amendment case must be built upon. While over 27 states have already embraced the liberty of constitutional carry, the remaining 23 states operating under restrictive regimes have just been served notice that their statutory frameworks are likely unconstitutional. The court has drawn a line in the sand. Historical tradition from the founding era is the sole litmus test that holds weight. This means politicians can no longer fabricate new restrictions simply to satisfy a modern political agenda. But the implications here are far more sinister than they appear on the surface. This is not merely about your ability to carry a firearm. It is the beginning of the end for a parallel system that has obstructed gun owners for generations. Rule number 2. The may issue permit regime is legally deceased. For decades, jurisdictions like California, New York, New Jersey, Hawaii, and Maryland utilized may issue statutes as a mechanism of control. Even if you navigated every background check, funded every training requirement, and presented a pristine criminal record, these states retained the arbitrary power to deny your rights based on administrative whim. In New York alone, rejection rates in certain counties soared over 40%, not because the applicants were dangers to society, but because a bureaucrat decided their reason for self-defense was insufficient. Consider the California model, where county sheriffs held absolute fiefdoms of power to approve or deny permits based on personal bias. The courts must now demand that the state produce historical analogs from the founding era to justify such discretionary power. And here is the reality. That evidence does not exist. Rule number 3. Administrative delays are now unconstitutional violations. Anti-gun jurisdictions discovered a loophole years ago. If you cannot legally ban the permit, you simply delay the issuance until the right becomes theoretical. We have seen jurisdictions dragging their feet for 3 months, 6 months, and in some egregious cases, a full calendar year to process a simple carry permit application. In places like New Jersey, the average wait time for a basic purchase permit ballooned to 89 days. Let's put this in perspective. You do not wait 8 months to cast a ballot. You do not wait half a year to exercise free speech. You should not be forced to wait nearly a year to secure the means of your own survival. Federal courts are now scrutinizing these processing delays as active constitutional violations in at least 8 different states. Illinois and Massachusetts are already staring down the barrel of lawsuits demanding they accelerate their glacial bureaucratic systems or face judicial mandates enforcing compliance. Time is no longer a weapon the state can use against you. The clock is now ticking against the regulators. But the weaponization of time is not the only tactic being deployed. They have also been hiding behind the facade of safety to impose financial barriers. Rule number 4. Mandatory training requirements can no longer serve as a blockade to your rights. Proponents of gun control champion mandatory training laws because they appear reasonable to the uninitiated. But the reality on the ground is a different story. States began mandating 8, 12, even 16 hours of exorbitant classroom instruction as a prerequisite for a permit application. Maryland demands 16 hours of instruction that drains your wallet of hundreds of dollars. Furthermore, this forces you to sacrifice income by taking time off work to attend classes that might only be available once a month. New York's requirements became so draconian that training courses developed 6-week backlogs, and citizens in rural territories found themselves without a certified instructor within a 100-mile radius. The Supreme Court ruling strikes at the heart of these logistical nightmares by posing a singular, devastating question. Did the American citizenry require government-mandated instruction to exercise their Second Amendment rights in 1791? But the training mandates are merely one layer of the obstructionist cake. Rule number 5. Background checks must be instantaneous, not indefinite. The Supreme Court did not dismantle the concept of background checks with this ruling, but they issued a severe ultimatum to states that abuse the process. These checks are legally intended to verify eligibility, yet certain states have transmuted them into a secondary delay tactic. California imposed a 10-day waiting period on top of federal checks, applying this even to individuals who already possess multiple firearms and have cleared the system repeatedly. Washington state engineered a permit-to-purchase scheme that injects weeks of delay and additional fees before the federal background check even commences. This ruling fundamentally shifts the burden of proof. It is no longer your duty to prove your innocence to the state. It is the system's obligation to prove your ineligibility, and it must do so with immediacy. The message from the High Court is undeniable. Background checks must be efficient mechanisms for public safety, not a form of punishment disguised as administrative process. Rule number 6. The good moral character test is finally facing a firing squad. Imagine a legal system where you are forced to prove your inherent virtue to a government bureaucrat before you can exercise a biological right. This is the subjective nightmare that good moral character clauses have inflicted upon gun owners in restrictive jurisdictions. In New York, this mandate evolved into a privacy invasion where police departments demanded character references from associates who have known you for years, alongside interrogation-style interviews where officials could probe any aspect of your private life. New Jersey empowered local police to reject applicants based on nothing more than a feeling regarding the applicant's trustworthiness. These vague, nebulous standards granted government agents godlike authority to distribute rights to the favored few and deny them to political undesirables. The courts are now posing the critical, destructive question: did the Founding Fathers require a character witness and a morality test before a citizen could own a musket? The answer is a resounding negative. Rule number 7. The sensitive place map is being torched. In the wake of the 2022 Bruen decision, anti-gun regimes attempted a strategic pivot by declaring virtually every square inch of public land a sensitive place where the Second Amendment does not apply. New York's retaliation was to designate Times Square, public transit systems, parks, bars, restaurants serving alcohol, stadiums, and private businesses without explicit pro-gun signage as no-carry zones. New Jersey's statute was so extreme it essentially rendered the carry permit a worthless piece of paper, banning possession in nearly every habitable public space. This Supreme Court ruling reinforces the hard line that sensitive place restrictions must possess a clear historical analog from the founding era. Banning firearms in coffee shops, on city sidewalks, and in public parks has zero historical foundation. The legal principle here is stark. The exception cannot become the rule that swallows the right entirely. Public carry for self-defense is the core component of the Second Amendment, and states cannot utilize creative zoning laws to legislate that right out of existence. Rule number 8. Red flag laws are now under the constitutional microscope. These statutes authorize the state to confiscate private property based on the speculation that an individual might be dangerous, often devoid of criminal charges or convictions. 19 states are currently operating under these regimes. While the ruling stopped short of striking them down immediately, it established a constitutional hurdle these laws must now clear. The vast majority of red flag laws utilize ex parte hearings, secret proceedings where a judge can sign a confiscation order based on a single testimony without the gun owner even knowing the hearing is taking place. The standard for issuance relies on dangerously vague terminology like significant risk, with no concrete definition. The Supreme Court's historical tradition test creates a catastrophic problem for these procedures because the founders believed in punishing actions, not policing predictions. States like Florida, Connecticut, and Maryland are staring at a potential total rewrite of their confiscation protocols to include actual notice, the right to counsel, and clear evidentiary standards. The principle is non-negotiable. Due process is not a luxury you lose in an emergency. Rule number 9. Federal agencies must now prove the historical pedigree of their regulations. This ruling is not merely a leash for state legislatures. It is a warning shot fired directly at the ATF and the DOJ. For too long, unelected agencies have been legislating from behind a desk, bypassing Congress entirely. The ATF's pistol brace rule attempted to reclassify millions of lawfully owned firearms as short-barreled rifles, threatening owners with felony charges and a tax stamp extortion scheme. The redefinition of frames and receivers attempted to regulate inert blocks of metal that have never been classified as firearms under federal statute. The crackdown on forced reset triggers classified a mechanical accessory as a machine gun, defying the mechanical reality of the device. The legal question courts must now answer is brutally simple. Did a bureaucrat in 1791 possess the power to criminalize standard ownership? This strikes at the heart of the administrative state. Agencies can no longer invent laws to satisfy modern political agendas or agency preferences. Rule number 10. Bruen 2.0. The standard has been weaponized. The 2022 decision was a massive victory, but this new ruling injects steroids into that precedent. It transforms the historical tradition test from a guideline into judicial armor that protects gun rights in every single courtroom in America. For 50 years, from the 1970s through 2020, we watched gun rights erode as courts applied weak standards and granted the government enormous deference. That era is over. Legal experts project this ruling will trigger an avalanche of over 100 new federal lawsuits in the next 12 months alone, challenging everything from magazine capacity limits to assault weapon bans to ammunition taxes. The momentum has completely shifted. For the first time in generations, gun rights advocates are on the offensive, while the controllers are scrambling to defend statutes that no longer have a constitutional leg to stand on. The constitutional revolution has begun, and these 10 rules are merely the opening salvo of a complete transformation in how America treats the Second Amendment. If you want to survive the legal crossfire and stay ahead of every regulation that threatens your liberty, hit that subscribe button and turn on notifications immediately. We played defense for decades, but after this ruling, we are finally winning. Stay sharp, stay informed, and never let anyone tell you your rights are negotiable.